Welcome to Module 2 of Private Lending Law course. In this module, we'll explore how foreclosure laws operate in the Western United States, focusing on key procedural differences and lender takeaways in states like California, Arizona, and Colorado. In this module, we'll review foreclosure laws in California, Arizona, Nevada, Washington, Oregon, Colorado, and Utah. These states generally favor nonjudicial foreclosure procedures, but each imposes unique notice periods, borrower protections, and process timelines that lenders must understand. Let's start with California, one of the most structured foreclosure jurisdictions. Here, most foreclosures are nonjudicial and handled by a deed of trust with a power of sale clause. The process begins with a notice of default, which must be served and recorded, triggering a 90-day waiting period. After that, a notice of trustee sale must be posted for at least 21 days before the auction. California also imposes the Homeowner Bill of Rights, which creates extensive protections for owner-occupied borrowers, especially concerning dual tracking and communication requirements. In Arizona, nonjudicial foreclosure is the norm. It's relatively fast, typically taking 90 days from the notice of sale. Nevada follows a similar nonjudicial structure, but includes required mediation in certain cases. Both states allow deficiency judgments in specific circumstances, but the rules depend on whether the loan was used for purchase or refinance, and whether the property is owner-occupied. Washington and Oregon also use nonjudicial processes when a deed of trust is involved. In Washington, the lender must attempt to make contact with the borrower and offer mediation before foreclosure can proceed. In Oregon, lenders must provide the borrower with a detailed notice of default and a chance to cure the default before initiating a trustee sale. Both states impose strict procedural requirements and deadlines, with penalties for noncompliance. Colorado has a unique process involving a public trustee who administers the nonjudicial foreclosure. The timeline is relatively efficient, about 4 months, with a strong emphasis on compliance with statutory notices. Utah also uses a nonjudicial system and has one of the fastest timelines in the region, usually between 120 and 150 days. However, minor technical mistakes can result in major delays, so attention to detail is critical. Let's compare these Western states across 3 key dimensions. First, timeline. Colorado and California offer relatively fast processes, while Washington and Oregon may be slower due to mediation and notice rules. Second, cost. Nonjudicial foreclosure is generally less expensive and faster than judicial options. Finally, borrower protections. California and Washington have the strongest protections, requiring more from lenders in terms of notices, timing, and mediation opportunities. For lenders operating in the Western U.S., here are 3 key tips. First, understand and calendar every notice and waiting period. Some states impose strict deadlines with steep consequences for mistakes. Second, plan your foreclosure timeline conservatively, especially in states with pre-sale contact or mediation rules. Third, work with qualified foreclosure trustees or local attorneys who understand the nuances of each state's requirements. That concludes Module 2. You've now seen how foreclosure procedures vary widely across Western states and how local laws influence everything from timeline to borrower rights.